this last decade. I have been the kind of judge who understands that it's my responsibility to rule neutrally, to not have any agenda when I'm looking at a case. I've been the kind of judge who understands that facts matter. Facts like the ones that I was just describing, and that it's important for a judge to take into account and be able to understand the arguments of all of the different parties and participants. And I've been the kind of judge who takes my responsibility to not be a policymaker, to try to understand and ascertain the will of Congress if it's a statute, or to adhere to my own, I've been saying stay in my lane, to not exert my authority beyond what the Constitution requires when I'm interpreting and applying the law. I think I've been the kind of judge who lives up to the oath in terms of being fair and impartial, ruling without fear or favor, and ruling consistent with Article 3.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. Senator Cornyn?
Moving on to John Cornyn, Texas Republican, in the second round of questions for Judge Ketanji Brown Jackson.
Well, you can think about having a little break, but just because the chairman keeps bringing this topic up, let me just ask you one question. When you accuse somebody of a crime, are you calling them a criminal?
Oh, Senator, I haven't accused anybody of a crime.
That's not my question. When in common understanding, in plain English, if you accuse someone of a crime, are you accusing them of being a criminal?
It depends on the context. It depends on what else you say about them. It depends on the circumstances.
It depends on the circumstances.
Yes.
So you put this in the same category as defining what a biological woman is?
No,
You're really not sure.
I didn't say I wasn't sure. I said it depends on the
circumstances. You are sure.
No, I said it depends on the circumstances that you're positing as to whether or not you're calling someone a criminal.
I just don't think that's credible, Judge. Let me ask you another question. You talk about the public confidence in the courts, in our institutions, which I agree are very, very important, that the public has confidence in our judiciary. Would you agree with me that to the extent that people perceive that judges, unelected, lifetime tenured judges, are making policy pronouncements or political decisions, that it undermines public confidence?
I do.
Thank you. Yesterday we talked a little bit about precedent, and I know Senator Feinstein, as she does in these hearings, talked about super precedent, and in particular Roe versus Wade. And I want to talk a little bit about that, but first let me just ask you, do you think there's any good reason for the Supreme Court not to overrule a previous decision when they concluded that that decision was wrong?
Thank you, Senator. Again, it's hard for me to answer that question in the abstract. What I'll say is that the Supreme Court has laid out factors beyond just the precedent being wrong as a reason to overturn it.
Well, we talked a little bit about this yesterday. The Supreme Court revisited the issue of separate but equal, which was the law, the constitutional interpretation of the Supreme Court under Plessy versus Ferguson, and overruled that precedent because
Yes.
it concluded it was wrong, right?
I haven't looked carefully at whether all of the different factors that the Supreme Court now uses to overturn were discussed in the opinion, but now the Supreme Court's precedent is to overturn on the basis of a number of different factors and not just whether or not it's wrong.
So are you suggesting that the Supreme Court could not or would not overrule a precedent that it determined was wrongly decided?
No, I'm suggesting that the Supreme Court's case law indicates that it looks at multiple factors.
No, I understand. You go through the stare decisis analysis,
Yes.
right?
Yes.
But if it's wrong, that's one of the factors that you consider, right?
Yes, but it's not the only one.
So are you suggesting that there may be circumstances under which the court determines its previous decision is wrong, but it will not overrule it?
The fact that there are multiple factors indicates that the court looks at more than whether or not it's wrong.
Okay, so so you would say, if I'm interpreting you correctly, that if the court concludes its previous decision is wrong, it won't necessarily overrule that. It applies a multi-point analysis.
Yes, I think that's
Okay.
accurate.
Back when Roe versus Wade was decided in 1973, generally speaking, the court said that the states may not limit access to abortion pre-viability, but post-viability, there could be some restriction on the right to abortion. Is that generally the...
As a general matter, yes.
Okay, thank you. Okay. Well, and then I think it's since 1973, the question of viability has risen again, what that actually means, because now viability was around 28 weeks. That is, the fetus could live outside the womb, but today, because of the advances in medical science, the fetus can live outside the womb after about 23 weeks. Is that your understanding?
Senator, I haven't studied this, so I don't know a number of weeks in the way that you're
Okay.
saying.
Well, let's talk a little bit about viability. The line that was drawn for pre-viability and post-viability analysis by the courts. What does viability mean when it comes to an unborn child, in your understanding?
Senator, I hesitate to speculate. I know that it is a point in time that the court has identified in terms of when the standards that apply to regulation of the right.
Justice Brennan, at a later point in his career on the Supreme Court, admitted that the viability line was an arbitrary line. Do you agree with him?
Senator, I'm not able to comment on viability. There's a case pending in the Supreme Court right now concerning the issues.
I'm asking you about previous decisions, but I hear you. No one suggests that a 20-week-old fetus can live independently outside the mother's womb. Do they?
I don't know.
I mean, the child will need to be fed or sheltered and all the other essentials to sustain human life. So there's no suggestion that after 20 weeks that a child can live independently, correct?
Senator, I'm not a biologist. I haven't studied this. I don't know.
You don't know whether an unborn child could live outside the womb at 20 weeks gestation?
What I know is that the Supreme Court has tests and standards that it's applied when it evaluates regulation of the right of a woman to terminate their pregnancy. They have the court has announced that there is a right to terminate up to the point of viability, subject to the framework in Roe and Casey, and there's a pending case right now that is addressing these issues.
the Constitution doesn't mention the word abortion, correct?